Okay, good afternoon, ladies and gentlemen. On behalf of the Center for Mediation and Conciliation and the Center for Alternative Dispute Resolution, RGNLU, we welcome you all to the last session of our web series titled A Career in ADR and Insider. Today's session is perhaps the most important session for many of us who are keen to pursue a career in ADR. Today, we're talking about international arbitration. Since it's a topic of wide interest and also our last session, we have two guests here with us, namely Rahul Donde and Trisha Mitra. We have a number of questions for both the speakers today, and they will be answering questions that they want to, adding on to the others' points if the other speaker feels the need to do so. We will also be taking questions from the audience, and feel free to drop any question that you have in the Q&A section. With that being said, I'd like to hand it over to my co-moderator to introduce the speakers here today.
Ms. Trisha Mitra is an associate at LA Live in 2020 since 2021. She specializes in commercial and investment arbitration, public international law, and advises on litigation proceedings in common law jurisdictions. She is also the managing editor of the European Investment Law and Arbitration Review and a peer reviewer for the dispute resolution publications of the Oxford University Press. Ms. Mitra obtained her LLM in International Dispute Settlement from Geneva Institute and received her BA LLB from Symbiosis Law School. Mr. Rahul Donde is counsel at Levy Kaufman Kohler and has acted as arbitrator, counsel, secretary, and assisted arbitral tribunals in over 35 international arbitrational proceedings. He is also honorary lecturer at Aberdeen University. He did his bachelor's from a government law college, Mumbai, and Mr. Donde obtained his LLM in International Dispute Settlement from Graduate Institute, Geneva as well, and did a master's degree in oil and gas law from Robert Gordon University. Without any further ado, we would like to begin with the questions now.
Thank you, Aishwarya. So, Rahul, Trisha, if you had to describe arbitration and international arbitration to a fresher, how would you go about it?
Well, I can take that. Firstly, thank you to all of the organizers for this invitation. It's my pleasure to be here and to give you my thoughts on arbitration and international arbitration. If I were to describe arbitration to a fresher, I would say it's simply an alternate mode of dispute resolution where the disputing parties are more in control of the process by which they resolve their disputes. So rather than two parties going to a court and following the court process to resolve a dispute or to resolve that dispute, in an arbitration, the parties come together, they decide what process to follow and how best to resolve their own disputes. It works almost parallel to the court system in the sense that the decision that you get at the end has the same validity, the same value as a judgment of the court. The main difference is that, as I've just mentioned, is that the disputing parties themselves get to set the process by which they resolve their disputes. And the reason why that is important is because very often you have very complicated and sophisticated disputes, and you would want someone that is qualified, competent, that has the background and the experience in that particular area to be able to decide on that dispute. So rather than explaining to a judge, what a pig is in the oil and gas industry, you appoint an arbitrator that has experience in oil and gas law, that knows what a pig is, can understand it, and already has a background, knows what its function is, and that can move on to solving the dispute. So arbitration, different mode of dispute resolution compared to litigation. Parties are more in control of the process, and the outcome, which is the award, is the same value and can be enforced similar to a court judgment.
Thank you for that insightful answer. Now, this raises another question. How were you made familiar to the field of arbitration, and what made you choose this field as your career path?
I'm happy to go first. I first heard about international arbitration. Okay, before that, actually, when I was a law student in India, international arbitration was not necessarily a specific course during my degree, at least. We had one component, but that was in our final year, sort of in our 10th semester. So I learned about it sort of, I think, in my second year when I heard a friend's senior, so not even like someone I knew directly, but was going to do something called a Vismoot in international arbitration. And I was like, what is this? What is international arbitration? And I just Googled it, I think, at that point. It sounded fascinating. So as one does when one's a law student, one sort of starts exploring different kinds of activities. So I was like, well, this sounds like something that I would like to do. And then I did ultimately end up doing the BISMO. And what I loved about it is I always knew I wanted to be a disputes lawyer. So the question was really, am I going to do litigation? And the other option quickly became international arbitration. And then the more I studied about it, and especially thanks to the BIS, I thought that it satisfied my curiosity in terms of doing the variety of disputes. I loved international law. I loved working with and meeting people from different countries, and sort of the international element that came with the cases and the teams you're working with. And I said, well, why not try this? And here we are so many years later.
Yeah, for me, the story was a little bit different. I was, like you mentioned earlier, I went to Government Law College in Bombay. And if there are any students here from GLC, and the GLC is exactly the same now as it was then, you end up doing a lot of internships while you're studying. So I was working while I was studying, but also in my final year. And there was a domestic arbitration dispute that came to the firm that I was working in at the time. And the partner I was working with told me, oh, yes, here's the arbitration, now go do. And I was like, but what does this mean? Like, what does go do mean? I had no clue of what it meant. And it completely amazed me that this is, that as counsel, we could set the rules ourselves, which is good. It sounds great, except when you have to craft the rules and you have no idea what you're doing. So it was, that was my first exposure to it. And that's why I think whenever anyone asks me, and my answer to the first question, I emphasized on the flexibility aspect. I think that's something that struck with me all through, which is that, it's a flexible process and the parties can craft the process that you want. So that was my exposure first to domestic arbitration. And then, like Trisha, I did the MIDS a few years before her. I did not do the MIDS for arbitration only. I did the MIDS more for dispute resolution, broadly understood. But I studied more of international arbitration. The way that it works was attracted by many of the same factors that Trisha was attracted by, and then continued with it. It was a hard choice, though, for me, I must say, because I was very keen on doing international trade law, and I had to choose between international trade law and international arbitration. And it's not the what would I say? It's not the most impressive thing to say, but it is the truth nevertheless, that one of the reasons why I chose international arbitration is simply because that was the first internship offer that I was made. So I received this offer first, and then I received the trade law internship offer, the day after. So if that would have not happened in that sequence, then maybe I wouldn't be here today. But now that I'm here today, no regrets about it.
Thank you both of you for that very deep and personal answer. Now that we have an understanding of what you do as a profession, I guess this question can be seen coming from a mile away. But what exactly are bodies such as the SIAC and the ICC, and why do they hold such significance in the world of arbitration?
That's a good question. So the SIAC and the ICC, and there are several other institutions, are essentially arbitral institutions. For those who don't know, and I suspect a lot of the participants do already know, but for those who don't know, the main job of an arbitral institution is to administer arbitrations. And so each arbitral institution has its own set of rules, which gives guidance to the parties and the tribunal on how to conduct the arbitration. So those rules will set timelines, it will give you guidance on fees, manner of submission of pleadings, manner of conducting hearings, general organization of the case, as well as dealing with procedural issues such as challenges to an arbitrator, etc. It is important, and this is somewhere where I would like to talk about what Rahul just mentioned, which is that when his experience of crafting the rules for an arbitration. So that was probably, Rahul, correct me if I'm wrong, an ad hoc arbitration that you were looking at in that case. And that is typically what one sees in India. The majority of cases, arbitrations in India are ad hoc arbitrations. But which means that then there is so much more for the lawyers to try to decide on for the procedure of the arbitration at a point when they're already at a dispute, which means that to arrive at even starting the case or getting the arbitrator to start determining the case, you're already probably looking at long timelines of trying to decide the procedure for the arbitration. And that is where I think choosing institutional arbitration is helpful, because you already have the parties have already chosen a set of rules, which can ensure the smooth functioning of the case, can ensure that there is time and cost efficiency, which is often a big advantage of arbitration over litigation. Some arbitral institutions even have sanctions if the proceedings don't meet the timeline set in the rules. Another big benefit of institutional arbitration is that some arbitral institutions will even review the awards for the tribunal and give advice on whether any part of it is likely to be non-enforceable in the future. So therefore, helping ensure that the award that the parties are receiving can be enforceable. And again, that leads to a time and cost efficiency of the entire process.
Thank you for your answer. Since you both are graduates of the MIDS program at Geneva, if you could please share with us your experience of the program. What do educational institutes such as NUS and MIDS look for in students when screening candidates? What role do internships play when applying for master's program?
Yeah, sure. I can answer that. My experience with the MIDS was great. I enjoyed my time there. But I think also the MIDS is a master's program. Yes. So and I think I get this question from a lot of people. Understand that there is a difference between doing a bachelor's degree and doing a master's degree. When you're looking at doing a master's degree, people expect you to know what you're doing. You can't just go in there and say, oh, free for all. You have to be aware of the program that you're getting into, and what you put into the program is really what you get out of it. You can very well coast through the program by putting in a minimal amount of effort, and then what you get out of it will be a minimum level of education. Or you can put in a lot of effort, and then what you'll get out of it is a really stellar education and a really stellar post-qualification, post-MIDS degree internship or job opportunity. So there is a level of, maturity that is expected when you're considering a program like the MIDS. So my experience was excellent, but also because I knew, and I think I had done a lot of research before applying to the MIDS, and I knew exactly what kind of environment I would be getting into. And at that time, the MIDS was new. I was just the third batch of the MIDS. But there was enough information out there for me to make a decision. And I would say that there were other people that were more disappointed with the MIDS because the masters wasn't what they were expecting. And when you're thinking of the MIDS, the best way of thinking of it, and I think this is potentially, we'll talk about this later as well, is that the MIDS is a procedural master's. It is not a substantive master's. It will teach you of the procedure of dispute resolution, the procedure of arbitration, the procedure of mediation, the procedure of WTO dispute settlement of the International Court of Justice. It will not teach you of the substance. So it's not going to teach you what IP law is. It's not going to teach you what energy law is. It's not going to teach you any substantive law. So when you're looking at the MIDS, if you go in with the expectation of understanding substantive law, you're going to be disappointed at the end of it. You're not going to have the experience that you thought that you would have getting in. So be very clear about what you expect from the program before you go in. One of the reasons why I chose the MIDS was because one of the professors at the MIDS was someone that I had followed for several years before, and that was not an arbitration professor. It was a trade law professor. And he was teaching at the MIDS, and I was very interested in doing trade law. And I realized that the MIDS made sense for me because he was teaching there, and because the WTO was there, and because I would learn more than just one stream of dispute resolution. I would learn about, WTO dispute resolution, the ICJ, investment arbitration, and commercial arbitration. So if you have that kind of a broader interest in dispute resolution, then I think that it is a good program. The second part of your question is what do institutions like NUS and MIDS look for? I really can't speak about the NUS, but I can speak for the MIDS. The MIDS is a small program. The intake per year is quite limited. And the applications, and I've reviewed many of them over the years myself, are excellent. The students that apply for the MIDS are really students that have an interest, or more than an interest, that can show an interest in international arbitration. So when you're applying to the MIDS, keep in mind that you're going to be applying amongst a cohort that is, quite experienced already in international arbitration. So you can't go in there and expect the educators to tell you what the difference is between institutional arbitration and ad hoc arbitration, for example. You would be expected to know that already. And therefore, what you're looking at, so then you have a pool of highly experienced candidates, right? So anything that shows a kind of diligence or an interest in dispute resolution, broader understood, I think is well appreciated. So that could be through participation in international conferences. It could be through writings. It could be through internships. It could be through participation in moot courts. It could be any number of things. But what you really need to show to the institutions, and again, I speak more for the MIDS, is that you have an interest in international arbitration, a tangible interest, one that is evident from your CV, and that you're looking at building on that interest, and that you're looking at refining the skills that potentially you already have, right? And I think that there's many opportunities for you to do that, especially today, less so in the past, but especially today. And many people say, oh, but, and now I'm turning to the third part of your question, what role do internships play? Many people say that, oh, but in India, we don't have the opportunity of, doing international arbitration internships. That is true. Maybe less true now than it was earlier, but that is also well known. You're not applying to a alien admissions committee. You're applying to an admissions committee that is very well grounded in reality, that knows that Indian students potentially do not have opportunities of practicing in international arbitration just as freshers out of college, and they don't have that unreal expectation. What they do know also is that it is possible to participate in moot court competitions, and that does show an interest in dispute resolution. They also do know that it is possible to write publications, to write blog posts, there are so many different things out there. There are now podcasts, there are interview sessions, there are multiple different opportunities through which one can show that there is a genuine, tangible interest in international arbitration, as opposed to simply saying that. And the simplest thing for budding students to do is, for example, to join the young members groups of all of these arbitral institutions that are out there. And that shows an interest too. You have conferences that are taking place all over the country that you can attend and then reproduce on your CV. So I don't think that anyone should feel disadvantaged because they have not done an internship, particularly in international arbitration. If you have done an internship, for example, purely in IP law, then you might be disadvantaged, as opposed to someone else that has done an internship in dispute resolution. But even in the first case, you're not going to be completely disadvantaged, because it is a question of showing that you are a professional and, for example, that you have substantive IP law knowledge already, and you're wanting to add on to that dispute resolution knowledge. So it's a question of, putting the best picture of you forward in a fashion that crafting a story that it is easy for an admissions committee to understand. And again, the admissions committee is not some alien entity, right? They are very much grounded in reality. So the more you make your story tangible, believable, and flow, the more attractive and more appealing it will be to the committee. I'm sorry for the long answer.
No, thank you. I believe your answer has certainly brought a lot of clarity to our viewers. Now, we have had this question for a while. ADR as a whole are procedures of dispute resolution. The matters that come up to you may be related to, say, maritime law or energy law. How do we reconcile an in-depth study of arbitration with maybe choosing a course or an elective paper on some substantive law versus focusing entirely on a substantive law and picking up a paper on arbitration?
Yeah, I believe Rahul has partly answered that already. I think it comes down to the LLM you choose. Courses like the MIDS, for example, will focus more on the procedural aspects of dispute resolution, and they will offer a few substantive papers. But if you go to other universities, let's say Cambridge, Oxford, Harvard, they have one or two, Georgetown, Columbia, they're all the same. They have one or two papers on arbitration or dispute resolution, and then you can have other courses on substantive law or other dispute resolution mechanisms. I think at the end of the day, it is ultimately what the person wants to do. If the person is sure that they want to definitely pursue a career in arbitration, a specialized LLM in arbitration might be the way forward for that person. That was the case certainly for me. I was sure that I wanted to do arbitration and I wanted to learn more about arbitration. When I did the MIDS, I had never even seen a BIT. That was sort of the background back in 2012 when I went to the MIDS. So I wanted to do an in-depth study of international arbitration and those mechanisms. Now, having said that, even if one does an LLM where, let's say, you're studying energy law or construction law or the law of remedies or conflict of laws, that won't necessarily prepare you for every kind of case that will come your way. The beauty of international arbitration, at least for me, is that you never know what your next case is going to be about. And in my case, it is very likely it is a case that I haven't done before. So I think that ultimately it comes down to what you want to focus on in the next step of your career. I can say that if you decide to do an intensive arbitration program like the MIDS, you really need to want to do arbitration because it is intense. It is primarily focused on disputes and arbitration. And I think that has been the cause of disappointment in some people that I've spoken who said that they wanted to do a more comprehensive, a more wholesome LLM, and they did not get that experience. So research the LLM that you are applying for, research it once again before confirming your seat there. And like Rahul said, there's certain maturity expected when you do an LLM, and that means that you need to know what you want from that LLM. I don't know if that answers your question completely.
Thank you. Thank you for giving such an in-depth answer.
Wait, if I can, I'd just like to add on to that. It's as Trisha said, right? It's horses for courses. So I think you have to be honest to yourself and understand if you want to do arbitration in general, more specific, or in general, and then a dispute resolution masters like the MIDS is the perfect one because it will give you that level of training. It will equip you to do that. But then it also you might feel, and that's what happened with me. I felt that I was not getting enough of the substance. I mean, when you're disputes lawyers, and this is true for any dispute, whether you're doing litigation, mediation, arbitration, you're like, I always think of myself as a bit of an actor, right? You act as if you know hospitality today, tomorrow energy, day after tomorrow, some other field of law. And I felt that wasn't good enough for me. I liked energy and I wanted to do more of it. And then I said, okay, you know what, let me do another master's in energy. But that was very much something that I realized that I want to do for myself, and I would have probably done even had I not done the MIDS. I think that there are two different decision processes that you need to undertake because what you get out of the two is very different. I also think that, when I chose to do the energy masters, I thought that it would be good because I've done the procedural masters and now I do the substantive masters, and then I will get a lot of work in energy law. And while I would like to say that that is the case, unfortunately or fortunately, it's not. There is a lot of work that I am doing. There is a part of it which is energy, but it's not the substantive. It's not the largest proportion. And simply that's the way that it has worked out. When I act as an arbitrator, I've been appointed in purely commercial disputes, more because of the dispute resolution experience that I have, and less because of the energy law experience that I have. So it's difficult, obviously, to micro plan everything at the beginning, but I think you will know fairly soon, if a particular area of substantive law interests you, and then by all means, I think a master's or another program in that substantive law should be pursued. And that's a decision that should be taken independently of whether you've done a procedural master's earlier or you plan to do one later.
Thank you for adding to the answer so insightfully. If you could suggest some publications or readings that are must for international arbitration newbies.
Yeah, I can try to take that. I mean, I must say that my basic reading of international arbitration is a bit outdated. I haven't gone back to the basics in several years now. But I think that the way I look at this is that it's like books. Yeah, it's like reading books. Some books you take to, some books you don't. You need to find one that appeals to you, that's written in the most convincing style. And maybe that's not the, the sexiest or the most popular one, but if it appeals to you in the style that it's written, then that's the book that you should follow. For me, there are two books which I would recommend. I mean, in terms of, for trade law, it was always Van den Bosch's treatise, which is excellent. And I think one of the best, from my perspective, one of the best legal books ever written. And for arbitration, it was the Redfern and Hunter, the original one. And I'm talking now in 2010, that edition. It has undergone now several revisions. I understand that there is a student handbook of the Redfern and Hunter out as well. I have not read it. But it was definitely the Redfern. So I think you need to find one that appeals best to you. And it's like reading any other book. You'll know maybe, 20 pages in whether you can continue or not. At least that's what happens to me with most books, right? You read for the first 25 to 30 pages and you know if it appeals, you continue. If not, dump it and choose another. What has changed is the fact that you have a lot of material which is now publicly and freely available. So you have a tremendous audiovisual library that is available online, and that might be the most appealing to many people. So you don't traditionally go by an education from a book, but you go for an education via YouTube videos, or ICA has a tremendous audiovisual library as well that can educate you on arbitration. UNCTAD, I think, has one of these courses on arbitration as well. So there's many options out there, and if you're not a very kind of reading from a book person, then there are many other options that you can take. What is important is, once you get the basics, I think it's important to stay current, and you need to be aware of what the latest developments are, see which way the market is evolving. And that's particularly important now when you think about this post-COVID world that you're in, where arbitration, the entire legal community, work, but also I would say arbitration is kind of undergoing a change where things are moving increasingly online, digitized. So it's no longer good to refer only to books that were written before the pandemic. You need to be aware of what the market is now. You need to make sure that that you have the right skill set to respond to which way the market is going to turn. So you have a lot of material out there on how advocacy, for example, has changed in a post-COVID, more remote online world. How, and that's both written as well as oral advocacy. How what skills are really needed for more junior lawyers to imbibe themselves with when they're looking at getting into arbitration, because you're not now expected to organize conference rooms and lunches and dinners and the like, but it's more how do you go about organizing, for example, breakout rooms in Zoom. How do you secure that? What are the cybersecurity protocols you have in place, etc., that more younger lawyers are expected to be aware of and to apply. So it's yeah, again, a long answer, and again, my apologies. Yeah.
Thank you, sir, for that answer. So, well, now since Trisha already spoke about it, let's assume that we're in the year 2011 and 2014. A young Trisha and a young Rahul have completed the master's from MITS. Please excuse us for thoroughly stalking your LinkedIn profiles. But we noticed that both of you have extensive long-term work experiences as interns and trainees. If we could delve into the experiences and how and when does one secure such internships in foreign firms, and what's the kind of work that an intern can garner from these internships?
Yeah, this is a question that that I've been asked often, and the answer keeps changing. And the reason the answer keeps changing is because there are more and more people wanting to study arbitration and get jobs abroad, which means that the market is getting more and more competitive. But the one I can explain what the process is like. Law firms invite applications for internships, and I'm talking about globally. And then I know we have a question later about jurisdiction specific processes, but I'll talk about more generally. Law firms invite applications for internships. Because the market is so competitive, often they are now interviewing 6 months to a year in advance of the actual role for those vacancies. Typically, those processes involve 1 or 2 interviews, and may or may not involve a written test, depends on the firm. Now, what is the kind of work that an intern can get from these internships? Again, it's a broad spectrum. It could be anything from assisting the team with a little more clerical tasks like proofreading and site checking, to helping them with research, to drafting memos, to drafting actual submissions, to assisting with hearings. It's a broad spectrum. I have seen that it depends on the firm, it depends on the team in that firm, it depends on the case, and it also sometimes depends on the profile of the intern. And what I mean by that is, let's say if there is a case involving Indian law and there is an Indian intern in the firm, it is very possible that the intern is asked to help with certain research and more substantive tasks. But what I have also seen, and this was certainly the case that I saw myself personally, is that because I had worked in India before as a counsel, the teams I was interning with quickly saw that I was able to take on more responsibilities, which meant that they started entrusting me with drafting and assisting with client meetings and experts, which not everyone else necessarily in my intern pool was doing. So I think it's a mix of what are the kind of cases and team that you're working with, as well as what you are bringing to the table.
Thank you. So, for how long should an aspiring lawyer intern before applying for an associate position?
I can answer that. It's a difficult question, but before I answer that, I just wanted to add to Trisha's question. Internships are it can go anywhere, right? Because different firms, as Trisha said, different firms follow different charts. What though does seem to be the case, and I think Trisha will agree with me, but if she disagrees, she'll say so. Is that you can now pretty well identify which firm follows what practice. And the way you do that is by speaking to people. Speak to past interns, speak to current people that are working there. That is evident from their websites. And it is unlikely that firm's practice might change. So the practice might change from firm to firm, but within a practice, the role of interns changing will be more difficult, not impossible, but you have a common base level expectation when you go in, right? And I think that you can get that information before you apply and before you start. Once you are there in any as an intern, I think what is important is two things, at least what I look at when I'm working with interns. It's the ability to work hard. That's evident, but it's also the ability to work sincerely. That makes all of the difference. And I can give you the two things are not necessarily the same. And I can give you a personal example. I was interning in Geneva while I was doing the MITS program, and it was exhausting. To put it honestly, it was tiring to have to go to classes and then to work and then classes and then work. It was exhausting, and I didn't really have the luxury of time. So I was working for a particular partner. That time wasn't a partner. And she had asked me to do some work for a conference that she was invited to speak at. So I was getting together the background materials and putting together a script for her to speak at. That was the role that was assigned to me. I was simply tired. And she said, "Oh, but how have you come on that research?" I said, "Yeah, I've done some superficial work, but it's really difficult. This topic that you've been asked to speak on. I mean, there's not a lot out there on it." And I said that off the top of my head. And I left her office, which was on the second floor, and I'm being very specific, so you know that this is a true story. I came down to the first floor, which is at the time where the intern pool was. And when I went to my email, I had received 10 emails from her containing 10 different links that were squarely addressing the topic that she had been asked to speak on. So you see that it's a clear signal. I mean, I should not have said that, I've spoken off the top of my head. I should have simply said, I haven't had the time to do it, which is the honest thing to say, but I'll get to it, rather than making a representation which could later, come around and bite me. So you have to be able to work hard, and you have to be able to work sincerely, and that is something which is very much appreciated. You also have to take a little bit of initiative. I mean, you're not where lawyers, our work is not that. I would say it is creative in a way, but not like painting creative. But you can take initiative. And that's useful. So maybe you're given a very dull and boring task, but you can apply yourself and say, okay, how about going about it this way? And I think that is something which is appreciated as well, taking initiative. And I think that Trisha has touched on, spoke about that already. Now, coming to the question then, how long should a lawyer intern before applying for an associate position? I don't think that there's a right answer to that question. I think there are two things that make a difference. One is it really depends on the quality of the internships that you've done. And maybe you've done one quality internship at a firm which is well respected, and that then is enough for you to apply directly for an associate position. Or maybe it's that you want to do 2 or 3 different internships and then apply for an associate position. It really depends. And again, when you're looking at appointing committees, we are not aliens. We are quite well aware of the market. We know if you've done an internship from X firm, what is the work that you've likely have done, what is the skills that you've likely have acquired, and we know how to value that internship. We know this, everyone knows this. It is, it's for you to change our mind. If, for example, you've done some stellar work, then you have to put that down on your CV and show it to me, that you've done this work in this firm, because otherwise there is a thought process that I'm carrying with me. Yeah. So it could be one quality internship, it could be more. What I think is important to understand is that a lot of people come to international arbitration having considerable work experience, for example, in India. And then they think that work experience that they have in India automatically qualifies them for an associate position abroad. And in some instances, it might well do so. But in some instances, it might not. And then you might be required, even though you have, let's say, 5 years of work experience in India as a working professional, post-qualification, for you to do an internship and then apply for an associate position. Because the work that you're doing abroad is not necessarily the same as the work that you were doing in India. So it would be maybe foolish for me to apply to an IP law firm and say, hire me as an IP lawyer now. Right? I have plenty of years of post-qualification experience. It's just not in the relevant field. So you have to be willing to take that step behind If you call it behind, I don't think that it is, but there is this kind of stigma that position, that titles have or create. Show that you have the background also in for example, in international arbitration, and then apply for an associate position. But you will also know this at your own. Intrinsically, you'll know this, and you'll know this when you're speaking to your market, right? You're all in an environment, the market is dictating many things, so you need to be aware of what the market is telling you. You shouldn't sell yourself short either, because that's a bad idea. If you don't value yourself, then no one else is going to value you. So if you've done 6 internships and you're applying for the 7th internship, that's going to create a question in the minds of any person, as it would in your own mind. Again, we're not aliens. We're very much human. And that's something to keep in mind as well. When you switch jurisdictions, I think you should be less, or you should be more cautious. But at least that's my view. I don't know if you have anything to add, Trisha.
Thank you for those answers, which I'm sure will prove very insightful later in our lives. Now, the next question that we have is, what are the qualifications required to practice in your current jurisdictions? We're talking about what bar examinations, what work experience, and what visa issues.
Right. I can go first. I am currently in London, so I'll talk about London. But I mean, I've worked in Paris in the past. I'm happy to answer questions. In London, there are essentially 2 systems at the pre-associate stage. One is the training contract, and the other is sort of the straightforward internship. Judging by Suanshu's reaction, it seems like many of the audience members know about these 2 systems, but I'll just outline briefly what they are. The training contract is essentially a 2-year program, primarily by English law firms, where you rotate amongst 4 seats. What I mean by 4 seats is 4 different departments. You could be doing 6 months in M&A, 6 months in IP, 6 months in arbitration, 6 months somewhere else. And then at the end, you qualify as an English solicitor, and the firm decides which seat to assign you to. So that is the training contract route. And the second is sort of the straightforward internship route, which varies between 3 to 6 months. Could be longer, subject to extensions. In London, what I have seen is that most firms have the training contract, and mainly the boutique firms, which is, for those who don't know, boutique firms are those that have just an arbitration team or just a disputes team. So they're not like the full service law firms, or the US firms that offer straightforward internship programs. What is the work experience required to be an intern? Frankly, none. But like Rahul mentioned, we do see interns that come in with having worked in their home jurisdictions. Visa issues, this is a very good question, especially in London, not so much in Paris. In London, the firm needs to sponsor you a tier 5 visa to be an intern. The way it works in London is that for a firm to be able to sponsor you a visa, they themselves need to be on a sponsored list. Most big firms are on that sponsor list, but there are a few boutique firms in London that are not. And what that means is that they will not be able to sponsor a visa for someone who does not have a UK work permit or a UK passport, which I suspect is the case for most Indian students. But having said that, I think the majority of the firms do sponsor visas, but that is a question, like Rahul said, when you're doing your due diligence about firms, that is a big question to ask, because if they don't sponsor visas, why would you spend time pursuing that opportunity? So that's that for London.
Thank you for your answer. Catching up with today, a lot of us have the same question regarding employment opportunities outside India. If you could share with us your reasoning behind wishing to work at foreign law firms.
Let me take that, but before I take that, let me just answer the question from a Switzerland perspective, yes, because there might be some of you that are interested in doing the mids and interested in working in Switzerland. Let me start with the last, that's the visa issues. And I think that is something which is very important, and that is the most ignored. visa issues are something that firms have to work with and individuals need to be aware of. If, for example, the country you're applying to, let's say Switzerland, has a limit on the number of non-EU nationals that the firm can apply, that are non-EU national visas that are available, then that firm is going to be subject to that limit. Now, if the news is telling you that that limit has been exceeded or has been exceeded in the month of January, there is no point in berating a firm for not following up with your internship application in the month of August, because there is no visas for them to apply for. So you need to be aware of the situation of the firm. You might not think that that is important, but from a firm's perspective, that is very important. So you might have the best resume in the world and you might be the perfect fit, but I'm simply unable to employ you because there are no visas that I can apply for. And that is the harsh reality of it. It's got nothing to do with you personally. It is the environment in which I work. And I think that law student, I mean, when you're pursuing these internship applications, associate position applications, and you start getting these rejections, at one point you start taking it personally and your self-confidence takes a beating. And in some instances, maybe the paperwork that you're using is not good enough and you need to bring that up to speed. That could well be the case. It could be that maybe you have an unreasonable expectation. So for example, let's say that you've done an IP law master's from Berkeley, and you're applying for a associate position at a dispute resolution firm in Switzerland, and then you're getting upset. But there's a kind of a mismatch unless you can explain to a Geneva-based firm as to why there is no mismatch and why you do and why you will add value to them. Or it could simply be a context-specific, nothing to do with you visa situation. So keep that in mind. One of the reasons why I chose the MIDS when I went to the MIDS was because the US was just coming out of the 2008 financial crisis, 2008-9. Law firms weren't hiring, or the ones that were being, the individuals, the LLM students, graduates that were being hired were those that had particular language skills, Spanish language skills. And I knew that I wouldn't be able to, even if I aggressively pursued Spanish, I wouldn't be able to do it within a period of a year. And it was important to me to be able to work in a foreign environment after I did my master's. And I said, okay, fine. That means that the US is basically not for me. And that is a decision that you need to take on the basis of all the factors that you have available. So visa issues are very important. In Switzerland, I can say the position is that for non-EU nationals, there is a limit on the number of work permits that are issued. And therefore, you need to be aware of the situation as far as those work permits are concerned. There's generally some press about it. So far, at least as far as my firm is concerned, we have not had any problems, but I know that other firms have faced those issues. In terms of work experience, in international arbitration, you don't need to have any particular work experience in Switzerland in order to get a position either as an intern or as an associate in international arbitration. So you could have work experience in Australia or in Chile. Many of my colleagues, I mean all of my colleagues, I would say, are from different jurisdictions spread all across the world. None of them have had prior work experience in Switzerland, and all of them have received associate and more senior positions. Bar exams in Switzerland particularly difficult unless you go through the entire legal education system. So you need to study law in Switzerland in order to qualify as a Swiss lawyer. There are a few exemptions that you get for certain subjects, but they are not really anything material. You need to go through the entire process. Also keep in mind that Switzerland has 4 official languages, neither of which is English. And the bar necessarily needs to be given in one of those 4 official languages. So you need to be fluent in either French, German, Italian, or Romance. That's as far as the question of Switzerland's position. Then to the question of the reasoning behind wishing to work at foreign law firms. The reasoning, at least for me, was that I wanted this foreign experience. I wanted to understand what was different. Actually, I wanted to know what the answer to that question was. It is, I can say that, at least for my experience, might not be the same for everyone, but it was quite different because you are in a very multicultural environment. You're working on disputes that are largely international. You are forced to study laws that you are so not used to studying. And I can tell you that civil law and common law are quite distinct. And now I've worked, I'm a common law lawyer, I studied in India, worked in India, but now I've worked in a civil law jurisdiction for several years. There are certain aspects where you just don't understand. The system that you've trained in is always the one that will seem the most sensible to you. But I wanted that kind of a broader exposure. And I also wanted to kind of, I also thought that it would be good for me to make, I thought of myself as being more international in terms of the career that I wanted to make for myself. It might not be the same for everyone, in which case, I know many people that have done the MITS, for example, because they wanted to have a broader understanding of international arbitration, but they were very clear in their mind that they would always do litigation and arbitration in India. So they went, they came, they did the MITS, they were happy with that, didn't bother to apply to any law firms at all, did not want that experience because they were very happy doing what they were doing and continuing doing what they were doing in India. And I think that's fine too. That's perfectly a choice that you can make. For me, I was like more, let's see what, globally, how things are and how things are different. And of course, you can never have a global picture, right? It's a little bit of the naivety, I guess, because the way a Swiss firm works is different from a way a French firm works, is different from a way an American firm works, and you'll have different experiences throughout, and you'll have different experiences even amongst firms in the same jurisdiction as well. So, it's very much a question of your own mindset, I guess.
Thank you for giving such a detailed answer. Many of our participants have recently graduated or have worked in a different legal field. The common line amongst them is a simple question. How does one go about starting a career in international arbitration? Any tips for us that you wish you would have received early on?
I'm happy to answer that, but maybe I've already spoken far too much. So I'm going to give a quick answer. International arbitration is by now a fairly sophisticated field, yes. So you need to be able to, having said that, it's not, like I said again, it's a field of law like any other field of law. So it's not as if you need to have some kind of special blessing or special knowledge to get into it. If you ask me, it's probably one of the least complicated areas of law to practice in, but that's just my opinion. You start with international arbitration just as you would start with any other field of law. You start by first, testing the waters. So if you're students, you have various options now. You have several courses that you can do. Some of them are available online. Some of them are free. So I would strongly suggest that you start with that first. Check if, doing these light courses, I call them, whether that's something that interests you. If that is something that interests you, then you can take it up a notch. And you take it up a notch by doing maybe a postgraduate degree, a postgraduate diploma, something like that. In the field where the level of education is a degree higher. And that's exactly, for example, what I did. I did a postgraduate diploma in international arbitration. And then if that's something that truly catches your fancy, and you think that you're willing to explore this at an even higher level, then you can even do a summer school. So you do a summer school in Geneva and Paris and London, in the US and Singapore, and in any number of places now that are offering summer schools. And again, you test the waters to a deeper level as to whether, this is something that you really want to do over the course of a summer. Having done that, and you're now convinced, by now you should be, either one way or the other, you choose whether you want to do a master's or not, right? And the master's, I think, really is the culmination of it. It really is, again, the master's is something that you put into it as much as you get out of it, as much as you want out of it. So there are people that can do the master's, that will do a master's at a very superficial level, and that will say, oh, but this master's was quite superficial and I managed to do everything, it wasn't complicated. And there are others that will do the exact same master's and have a completely different opinion. At least that's true for the mids. if then you do a master's, and by then what you are doing to prospective employers is to show that you have a steady evolution in international arbitration. You started from, you really built a career in it as far as the academia is concerned. At least you can marry the academic studies with an internship or two, or a publication or two, or something else. Attend international conferences. You follow all of these various blog posts, etc. And that's how you get into it. I don't think that it's any different from getting into any other field of law.
Thank you for your answer. Moving on, is it fair to say that to enter the US or EU market, one first needs to have an LLM from an international university?
Let's just say that it is not a written rule and it's not a firm requirement. But for many of the reasons that we've discussed in the past, which include the fact that if you're coming from a jurisdiction, if your previous experience, whether it's academic or professional, has been in a jurisdiction which is not within the US or in Europe, then firms prefer to have candidates who have an LLM, and which sort of is almost like a guarantee that the candidate has sort of a basic understanding of the law, the practice that the firm is practicing in. The LLM, I think, also guarantees that you will have. Let me put it the other way around. The LLM can often be a way for you to meet the people who are active in the US or the European market. And I think that's actually another distinguishing factor between, going back to our earlier question, of choosing an LLM that is only arbitration and choosing an LLM that is sort of a mix of everything. I can say that at the MIDS, all our professors were sort of the foremost practitioners of arbitration around the world, which means you have great networking opportunities. Often many of those people are the ones either giving you an internship themselves or recommending you for internships, which has been the case for many people who have done the MIDS. And that is a step in compared to, let's say, other universities where where arbitration is just one paper. So when they have, let's say, a job fair or when they have networking mixers, you might not be necessarily running into the people who are running the arbitration teams. So it's not a hard requirement. There are certainly people who are working in arbitration who haven't done an LLM. But for people with backgrounds coming, let's say, from India or many other jurisdictions which are outside the US or Europe, I think it sort of creates a familiarity, or at least a certain stamp of approval for firms. And you see that now, and I see that now with the MIDS. Now that we've had so many batches, that you'll see alumni from your LLM at these very firms that you want to work with. And hopefully that alumni has created a good impression at the firm, which means that the firm thinks that LLM assures a certain quality as well.
Thank you for dealing it with in such depth. Moving on, what are the kinds of job opportunities provided to international students in international arbitration? How do you separate yourself from a pool of candidates?
Yeah, I can take that. I think the job opportunities are several, but when I was doing law school, the fashionable thing to do was to do IP law. And then everyone wanted to do IP law because IP is international and IP will allow you to travel and you can do you can work at the WIPO and what have you. And that was like the big thing to do. And everyone then like a herd of cows was doing exactly that and trying to do that. I think that arbitration is kind of subject to the same thing. So there are multiple opportunities, but people automatically think of internship at a large law. So I want to intern at Allen & Overy, I want to intern at Clifford Chance, I want to intern at, take your pick. Laliv as well, because now Laliv is quite global. That's obviously an opportunity which is available, but that's not by far not the only one. You have arbitral institutions, and Trisha has already touched on them. The SIAC, the ICC, that are doing tremendous work. Going and working in those institutions exposes you to an area of international arbitration which cannot simply be replicated by any law firm anywhere else. So arbitral institutions are an option. There's ICSID is another institution where you're also given, you also have more hands-on experience, what do I say? Words are escaping me. You are more hands-on on the disputes that you're handling. So you have arbitral institutions. What you also have is the opportunity, and this is especially in a post-COVID world, right? You have the opportunity of sitting where you are, wherever in the world that might be, and working with individuals that, for example, are sitting as arbitrators. So you could sit as work as tribunal secretary. When I graduated, the tribunal secretary thing was something which was not as well known as it is now. Now you have all arbitral institutions that are running tribunal secretary training programs. So that's something that you can do. You can offer your services. You can do one of those courses, and offer your services as a tribunal secretary to an arbitrator. You could offer. You could also work for the arbitrators themselves, maybe not officially as a tribunal secretary, but doing some research work and the other. It's really what you make of it, and in some instances, maybe it's up to you to create or to think of a role. The other question as to how you separate yourself from a pool of candidates, I think that is tricky, right? But at the same time, you kind of already know, because you know what edge you have to everyone else. There is something that you've done. No two people are the same, and no two backgrounds and no two experiences can be exactly the same. There is something that you've done differently. It's just a question of how you put that out, and you have to be obviously reasonable when you're doing that. To give you an example of unreasonable, is an Indian law student, excellent credentials, a very good university, good internships, that says, oh, now I'm going to apply for my internships abroad. Good for you, excellent, well done. And then sends his internship application, and I am not joking, sends his internship application to every single member of my firm at the same time, on the same day. I don't know what rational thought process there was in the mind of that student. What did he expect would happen? You send like your internship application to everyone in my firm, and then what happened is, because at the time I was the only Indian working at the firm, everyone, including from the founding partners to the youngest associate, forwards that email to me. So I have everything double now, saying, oh, but look at this, oh, but look at this, oh, but look at this, can you explain what is this? And I'm like, I am not representative of him, I have no idea who he is. But you know things, I mean, I'm sorry, but you realize this, and you're a professional now. You should know what is reasonable. So definitely you should try to separate yourself from the pool, but don't do unreasonable things that will irritate and aggravate you if you were at the receiving end of it, right? Another thing I think that people don't do enough, and what they should do is, and definitely what y'all have done for this conference is a lot of background research. So you need to be aware of the firm that you're applying to. If your interest is, for example, in investment arbitration only, and for some reason you like to represent states, you like to work for states, then you're better off applying to certain firms like Curtis Malley and Foley Hoag that represent states. If you are in a mindset where you're more commercially minded and you want to advise private companies, then you're better off not applying to those firms. So you need to be aware of the context in which you apply. If you want to do, again, for example, investment arbitration, and you apply to a firm that is only doing commercial arbitration or commercial litigation, that's not going to work well either, unless somehow you can show to them that what you have done in the past is can be fitted into their practice in a fashion that will add value. Because what I'm looking for is someone that can add value to my practice. Show me how you add value. Simple. It's nothing more complicated than that. And when you have that front and center, you are, I think that you produce an application which is much more reasoned and much more attractive and appealing to the recipient.
If I could just jump in, I think it's important to separate yourself from a pool of candidates, show why you add more value to the firm than the others. I think it's a fine line, though, between standing out too much and separating yourself. And I say this because we sometimes see interns who are keen to make their presence felt, and they are everywhere you turn, they are there. You're in the office, and they are always trying to hang out in your office. They won't leave you alone, whether it's at lunchtime or you're just having a coffee break with a colleague. It's almost like stalker-like behavior, and that does, you do come to the attention of everyone, but not necessarily in a good way. As opposed to that, showing your credentials, speaking out and saying that, listen, I can't take on this opportunity. I see that this team is working on so and so. Can I help with the research for this? Can I prepare a memo for you? Say that, I have previous work experience, let's say in IP law, and I see that your firm is doing an IP law case. Could I help? I actually did that when I was working at my previous firm, and there was a case against India. This was the Cairn arbitration against India. When I was an intern, the case was just about to kick off. I was not put on that case. I guess the firm hadn't realized that there's an Indian intern, or it just hadn't crossed their mind. And I had written to the partners on that case and said, hey, I exist. You have a case against India. Would you like me to be involved? So that helps you sort of also bring your credentials and your background to the attention of the team. But like I said, it's a fine line. You do not want to be pestering your team either.
Thank you for those great insights, which are also slightly funny, if I may say. Then, do you have any substantive areas of law in international arbitration that you specialize in? And if so, could you share your thoughts on the work that you receive in that area and the processes that follow after that?
On my part, I say, like I said, substantive areas of law I've done an energy law master. So part of the work that I do is in energy. But I would say by far the most work that I'm doing is in purely commercial law. In energy, because of the value, the ticket sizes are fairly large. You have fairly set processes. So it's generally referred to an institutional arbitration, and then you follow the rules of that particular institution. Maybe making a few modifications along the way, but nothing very different from what you would anticipate an ordinary arbitration to be. So you have your 2 rounds of submissions, you have potentially document production, then you have another 2 rounds of submissions, 1 round of submissions, and then the hearing, post-hearing matters, and then the award. In commercial, the purely commercial disputes, I think the processes are different because a number of them are ad hoc, and then you can craft the process yourself. And then it can really change. I also sit as an arbitrator, and the processes that now I'm increasingly coming to adopt myself are different from the standard process that I've just mentioned for energy disputes. So now I'm doing more of a process, of course, subject to the nuances of the dispute itself, where I do 1 round of submissions, case management conference followed by questions from the tribunal, which is me, simultaneous answers, and if necessary, simultaneous replies. And I think that is a process which is, for a certain kind of dispute, is more efficient. It cannot be clearly adopted for every dispute because there are various kinds of disputes and disputes of various complexity and value. And that's really the majesty of international arbitration, right? You can do a process in one and a completely different process in the other. So it's hard to say that there is any one process that is followed. And currently, at least for me, it's hard to say that I'm working exclusively in energy law.
Yeah, as for me, I personally prefer not to specialize in any one area or sector. Right from my litigation days in India, I've had a sort of I will do whatever comes through the door kind of philosophy. I think that keeps it. I think that ensures variety. That keeps work interesting, and I love learning about different sectors and different countries. So I can tell you that so far I've worked in a range of industries, be it oil and gas and renewable energy, which has been actually, again, a lot of my work in the past. But I've also done infrastructure, I've done mining disputes, I've done telecommunications, pharma, IT disputes. And I've enjoyed all of them, but do I want to only stick to them? Not necessarily. I obviously have now gained industry knowledge in those sectors, but I look forward to learning about more sectors and working in those sectors. And I can say that recently I've realized this without any effort on my part, but after the Cairn arbitration against India, some people think that I have a specialism in tax disputes. I won't confirm or deny that.
We will send you all of our tax matters, Trisha. You should embrace it.
I'm trying to. I recently got invited to write a book chapter for an upcoming book on tax and ISDS. And I said, well, clearly someone out there thinks that I'm qualified to be doing this. So I said, why not? I have some things to say about it.
Yeah.
Thank you for those very great insights. Now, could you all share a day or a week in your life? What kind of cases are on your docket and how you go about it?
I don't think it's anything different than what I've said. My work right now is mostly involves me sitting as arbitrator, and I've received interesting appointments over the past couple of months. So that's keeping me busy. Again, the processes are vastly different, and this potentially touches on a question that you have later on, because I'm sitting in ICC cases at the same time I'm sitting in domestic ad hoc arbitration act cases, and the difference between those is sometimes quite stark. The expectations of the parties are in both of those are vastly different, right? And I think that that is something that you have to be particularly careful about, because there is a certain expectation that the parties have been fed by their representatives counsel in domestic arbitration, and the same in an international arbitration. And then while as a tribunal, you think that, this is all inefficient and you want to change things completely. At the same time, you have to be sensitive to the fact that arbitration is very much a creature that is a creature of the parties. And if the parties tell you that they want to follow, a set procedure, you can resist and ask for modifications, but only up to a point. And that's, I think, that's something that is quite different. I'll give you a real example. In this domestic arbitration that I'm presiding over, there's an expectation in the parties that a WhatsApp group will be created on which urgent applications can be made. Now, I appreciate the fact that there can be urgency, but I just don't see why I need to create a WhatsApp group for it. I mean, what can you convey to me on WhatsApp that you can't convey to me in an email? I don't really care where you send me the email from. And if I get an attachment on WhatsApp of an application, am I, to me, how am I going to give you directions? How am I going to ask the other party to answer? How am I going to be certain that, that service is complete, etc.? So, there are practical nuances. But the expectation is that there will be a WhatsApp group, and then you have to explain to them to say that there is nothing that can be so urgent that only WhatsApp is the only medium. Like, surely you can take 2 minutes to send an email, be it from Gmail or what have you, and expect a response, right? Unless there's some real situation where WhatsApp is the only available mode of communication, but that would just baffle me. It would make some tech giants very happy if that were the case, but I don't think that that is the situation anywhere. So it's really really depends. When we act as counsel, it's not very different from acting as a counsel in a litigation firm. You're liaising with the clients, you're getting the documents together, you're making a case. I have also done a lot of work as tribunal secretary. When you sit as tribunal secretary, the role that you're expected to perform is different because you have an overview. I mean, you have an overview of the entire dispute. So you're assisting the tribunal in the decisions that the tribunal is making. You're, some instances summarizing the facts in dispute. You're churning through the witness and expert evidence. You're churning through the documentary evidence. So it varies. I am not as facetious enough. Okay, I can never pronounce that word, but enough to say that every day is a different day. It's not. But overall, if you look at the various tasks that are done, they are on a bigger picture, on an outside view, they're different. Yeah.
As for me, I think I'm lucky enough to be at a firm that has a fantastic variety of cases. So currently, I am involved in a commercial arbitration regarding the construction of a road in a Central European country. We are actually right now, so I mean, going back to your question of what my week looks like right now, we are in hearing prep. So we have a hearing in early September. So I look forward to, cross-examining experts on construction defects and the quality of tar and concrete slabs. That's going to be
far too enthusiastic about that.
I love it. I love it. And my other two cases are actually mining cases, investment arbitration cases against Poland. Again, very interesting issues about quality of coal and what is coking coal and what is thermal coal and feasibility of mines and project financing for the mine industry across the world. So yeah, that's something that's a filing that I just finished. So these are sort of the cases that have been on my table for the last few weeks. Alongside this, I mean, I think it's the same for Rahul. Sometimes your weeks are completely unpredictable because something will come in, a client will ask for advisory on a certain issue and they want an answer within a couple of days, or they want to present something to their board on a completely different issue, and you have to sort of turn that around. But that's sort of what my week looks like.
Yeah, at the cost of being cynical, I want to dispel this notion that many people seem to have that doing international arbitration means that you're doing something exciting all the time. It's not. It's clearly not. Like,
how is that notion wrong? I think our cases are exciting.
Yeah, but I mean, okay, fine. But you are far more, you have the enthusiasm, which is lacking. I mean, not all of the work that I do all of the time is super exciting and super interesting, and I'm super, involved. And I'm like, oh, let me get up in the morning and hit this day with, energy and gusto. It's simply not the case. Some work is shit, but you just have to do it, because that's what the role involves. And I like to. There's this notion that people have, international arbitration means you're flying from one place to the other and attending these fancy conferences and this, that. And like, dude, like 1 week of hearings is so exhausting. You'll wish you never had it ever. It's completely disjointed from reality sometimes.
Thank you for those alternating views that have left us all confused. But moving on, what are your opinions on the differences in the arbitration practices in India and let's say a comparison with the EU and the arbitration practices over there?
I don't know. I would say that now there are arbitration teams in India in large law firms that their practice is exactly the same like how I'm used to seeing it in Switzerland. They do very well. And I'm exposed to a large number of these practices in my work, and their job is fabulous. Sometimes even better than the firms or so-called good firms, the stalwarts of international arbitration abroad. There is, of course, So when you're talking about international arbitration, I think that the practice is fairly regular or regularized. You have a base level of professionalism which is involved, and that professionalism is showed by both international firms as well as domestic firms in India, and equally not shown by both international firms and domestic firms in India. There's nothing so special or so unique about a firm just because it's located outside of India. It's not necessary that they'll do a really good job, and just because it's in India doesn't mean that they're going to do a really bad job, right? So as far as international arbitration is concerned, I think that it's fairly the practice is fairly standard. As far as domestic arbitration is concerned, then the Indian practice is different. The ad hoc practice, everyone is quite well aware of. In terms of the high ticket value, you have retired judges as arbitrators. Again, I have no problem with that. I have no problem if you appoint a retired judge as an arbitrator. I don't see any issue with that at all. And in fact, in the UK, for example, you have a lot of retired judges that sit as arbitrators, and nobody has any questions or any complaints about that. The problem is with the process which is followed. The process which these retired judges apply is a process which is often bulky and very often expensive. And that is a problem which I think needs to be identified, spoken of, and only then can be resolved. And the reason why nobody really speaks of it is because the people it's convenient to blame a retired judge, right? Because they're not present in all of these international conferences. So they can't stand up for themselves. Who are present are the law firms. And the law firms would like nothing better than to pass the buck. So if you have a firm that appoints a retired judge as an arbitrator, but tells the arbitrator that I want this dispute resolved in 6 months, otherwise I'm not appointing you, the judge will either accept that mandate or not, but you'll have an outcome. So I think that level of confidence and that level of forcefulness is now coming into the domestic arbitration market. And the arbitration that I'm involved in, for example, the expectation was very clear that the award will be handed out within 3 months after the hearing. And this was communicated to the arbitral tribunal very clearly and very early on. And that's refreshing. And that's then heightened, you're kind of, elevating the practice, the domestic arbitration practice to a more common international arbitration practice as it applies domestically, if that makes sense. And that's a good thing. But arbitration is something which is, I wouldn't say it's new to India, but has been looked at with some skepticism by the Indian courts in the past. That attitude is now slowly changing. To expect that attitude will change overnight is wrong. But to not take efforts to change that attitude, I think, is also.
If I could jump in, I have another sort of take on this. I think one difference that I still see in the arbitration practices, and I'm being careful, practice versus team. Arbitration practices in India as compared to, let's say, Europe or Singapore or the US, is that I'm still seeing that a lot of the firms in India are working as co-counsels with foreign law firms on international cases. And what that means is that, unfortunately for the Indian firms, they are sort of the Indian law specialists, whereas the foreign law firm will often do sort of the bulk of the advocacy work before the tribunal. And perhaps that is one of the main reasons why I wanted to move to a foreign law practice, going back to your question, Aishwarya. I see that's changing. There are a few teams now that are doing international cases, even investment cases, completely on their own, maybe with the help of a barrister, but completely on their own. But what I'm also noticing is that there's this interesting trend of Indian firms now opening offices in London or, say, Singapore to actually divert their own work in a way back to them. I don't know if that makes sense, but if there's an Indian client that has a case, let's say, seated in Singapore and wants a Singapore-based firm, or has an LCIA case and wants a London-based firm, these Indian firms now have desks in these locations saying, well, we are on the ground. that's an interesting trend, and what that might mean is that if the future of the arbitration practice of India is more teams handling the work on their own without foreign law firms. But as of now, I still see that the foreign law firms are doing the bulk of the advocacy work before the tribunal.
Well, moving on to the last remaining bit of questions that we have, how can an Indian lawyer build his or her credibility in the field of international arbitration like you all have?
I think we've sort of touched on many of these in the past. So, I mean, Aishwarya, Suvansh, if you have more specific, if there's anything specific you want to ask, please do go ahead. But work experience, internships, LLMs, publications, research, showing consistency in your work, hard work, are all important. Building a profile for yourself is a big part of credibility as well. It depends on what stage of your career you're at, but sort of an amalgamation of all of these, I would say.
Thank you for your answer. Ms. Trisha, with your experience as a managing editor in the European Investment Law and Arbitration Review, and Mr. Rahul, with your contributions to the TDM issue, would you like to share the importance of research and publications in a field like arbitration and international arbitration, which are considered to be more practical than theoretical?
Yeah, I'm happy to go first. I think arbitration, because it is such a dynamic field, and the kind of cases that we're seeing is ever changing, and so there's so much, like if you're working in international arbitration, developments in any part of the world could be relevant to you. I think keeping yourself updated is very important. So that is the research part of it. Publications are important for profile building. I enjoy publications because they allow me an opportunity now to sort of go in depth into a topic which your casework does not necessarily allow you to do. I would say it is quite important. Being the managing editor of the European Investment Law and Arbitration Review, I completely enjoy that experience because there's a lot happening in Europe and investment law. I joined a year before the ACMEA decision came out. And for those of you who don't know, the ACMEA decision basically said that BITs between two European countries, arbitration between two European countries is not allowed under EU law in a nutshell. And what that has meant is that, I mean, there have been so many developments in EU and investment arbitration sense. So it's been an absolutely fantastic gig to be the managing editor and see all these publications come in, often with contradictory views. I remember the edition right after the ACMEA decision, we had a person from the legal department of a European country submit a publication, and then there was somebody else, a private practitioner who often represented investors, also submitted a publication, and they were completely contradictory each other. So we had a gala time editing that edition. Yeah, so keeping up to date and having the opportunity to learn a little bit more about the field, I think it's important.
Yeah, I can only second that. I can say that it's important also if you're a student and you're looking at building a career in international arbitration and pursuing a master's program or any other program. You want to be aware of the latest developments. You also need to show that you're aware, publish on areas that you find interesting, and that helps to portray this image as being a all-round arbitration professional. So I think that that's important from that perspective as well. And there are many opportunities. I mean, I think there are many publication opportunities available now. You might not have the time to write a thoroughly well-researched, well-footnoted, perfectly edited piece for the European Investment Law and Arbitration Review. But you might have the time to put together a fewer arbitration blog post or a Youngika blog post or something of that nature. So I think there are multiple opportunities out there, and it is definitely important.
Thank you for your insights. Coming to the last question of the evening, since we've already kept everyone here for a little longer than expected. What is next for the both of you?
I wish I knew. Ideally, as I think I've answered publicly before, having a pina colada on a beach somewhere, but it's difficult to say. I'm quite happy with the work that I'm getting and doing right now. So things can well continue. No complaints.
Yeah, I mean, there are bars on the Juhu beach, Rahul, since you're in Mumbai. For me, I mean, I do have professional goals. I mean, things I want to achieve going forward, but I'm afraid of jinxing them. But what I can say is that I'm passionate about arbitration, and I want to keep growing my skills and my practice to be the best possible lawyer a client can have. Client from anywhere in the world, from anywhere in any industry can have, and that will continue to be the driving factor.
Her answer is much better than mine. I'll take it.
I'll join you for the pina colada any day.
With this, we come to an end of the very well-received web series collaboration between Center for Mediation and Conciliation and Center for Alternative Dispute Resolution, RJNWIL. On behalf of the organizers, the managing crew, and the audience, I extend a very hearty vote of thanks to Ms. Trisha and Mr. Rahul for gracing us with their ingenious knowledge and experiences. We are grateful and pleased that you accepted our invitation to conduct this session and coach the students on the various facets of international arbitration. There could have been no better way to conclude the series other than this illuminating session on the intricacies of international arbitration, and we hope you enjoyed it as much as our audience. I would also like to thank the attendees for their amazing enthusiasm for the webinar series. We hope that you have all enjoyed this sessions and the series and were also able to derive helpful knowledge and perspective. I'm sure that the audience would agree with me when I say your combined expertise and insights in international arbitration is something we cannot get enough of. On this note, we conclude the session and web series. Thank you for joining us.
Thank you very much.
Thank you.
Thank you. Have a lovely evening.